Thank you for coming out to this Research Group on Constitutional Studies lecture. The Research Group on Constitutional Studies, a unit of the Jan P. Lin Centre for the Study of Freedom and Global Orders in the Ancient and Modern Worlds, brings together scholars at all levels from across faculties and departments at McGill, primarily political science, law, and philosophy, of people who study in a variety of ways and using a variety of methodologies the foundational principles and organizing structures of political and legal orders. We include empirical political scientists, normative political theorists and philosophers, philosophers of law, constitutional and public legal scholars working in a variety of historical, jurisprudential, and empirical traditions. We include faculty at all levels, postdoctoral fellows, a fellowship of PhD students, and a fellowship of BA, MA, and JD students, the Charles Taylor Student Fellowship, whose members are all here tonight, and one of whom will ask the first question at the end of the lecture. We are moving toward the time of year when, if you are a future BA, MA, or JD student, that is to say someone who is not graduating, and you are interested in potentially joining the Taylor Fellowship next year, to let me know that you would like to receive the application information for that over the summer. The Taylor Fellows meet in a weekly reading group to study major works in the history of political, moral, and social thought, as well as related works of literature, while the PhD students, postdocs, and faculty have a variety of research settings in which they work together. The RGCS Lecture Series invites leading scholars to McGill to present their research on the values, institutions, and principles of free societies. We ask them to do so in a way that brings their excellence in research and their excellence in teaching together, insisting that those should be joined skills, not separate ones, and that even world-leading researchers on those subjects ought to be able to present their ideas and research in ways that are accessible to really terrific and intelligent but early-stage students. We ask the speakers to rise to that occasion. We ask the students to do so as well, and to be willing to engage with genuine, serious, difficult research. We meet today at McGill University. We recognize and respect the Kanyen Kehana as the traditional custodians of the lands and waters on which we meet. This place has long served as a site of meeting and exchange amongst many First Nations, including the Kanyen Kehana of the Haudenosaunee Confederacy, the Wendat, Abenaki, and Anishinabeg nations. Today we have what is turning out to be the second in a kind of funny accidental trilogy over the course of the year of leading scholars of constitutionalism, constitutional democracy, and constitutional backsliding across a variety of settings. The first of these in the fall at the inaugural conference for the Diamond Brown Chair on Democratic Studies was the visit from Stephen Levitsky at Harvard. I will talk about the third event in that informal trilogy at the end of tonight's session to encourage you to all come to it. But for today, we are delighted to, for the first time at RGCS, though not his first time at McGill, extend an overdue but very warm welcome to Tom Ginsburg. Tom Ginsburg is Leo Spitz Distinguished Professor of International Law, Ludwig and Hilda Wolff Research Scholar, Professor of Law, Professor of Political Science, the Faculty Director of the Lin Centre for the Study of Institutional and Legal Integrity, the Faculty Director for the Forum on Free Inquiry and Expression, and the Co-Director of the Comparative Constitutions Project at the University of Chicago. He absolutely exemplifies the unity and shared areas of inquiry that characterize the kind of work we aspire to at RGCS. His work crosses the boundaries from doctrinal law comparative law and constitutionalism, empirical political science, and normative inquiries into fundamental organizational principles. He has the kind of CV and career that forces an introduction into something that is more like counting than recitation. He is the author or co-author of 7 books. He is the editor or co-editor of another 28, with half a dozen major best book prizes among them. He has held faculty or visiting faculty appointments in half a dozen countries. He has advised or served in some close capacity Supreme Courts and commissions on constitutional reform and international courts at half a dozen different times over the course of his career. He holds BA, JD, and PhD degrees from the University of California at Berkeley. His PhD was in the Jurisprudence and Social Philosophy program of what was then the Bolt Hall Law School and is now the University of California, Berkeley Law School. And that JSP program is a program that is in its own way very akin to the combination of fields of inquiry that we aim to here. Among his fields of work, not what he's going to talk about tonight, but something mentioned in the long list of job titles, is that he is a leading scholar of and really serious faculty activist, if that's not a paradox, on questions of academic freedom and freedom of expression on campus. In a happy coincidence, the major report from the panel on free expression on campus that was just issued at McGill last week, 2 of whose authors were an RGCS faculty member and an RGCS PhD student. That report, by happy coincidence, cites Professor Ginsburg's works on those questions some 8 times. And that is not what he's here to talk with us about tonight. He has established himself over the last decade, drawing on his long-standing previous work as a comparative constitutions scholar, thinking about constitutional texts and constitutional structures from a global and comparative perspective. He's established himself as a critically important voice in the scholarship on constitutional maintenance, constitutional risk, and constitutional long-term preservation. He's going to come and talk with us tonight about questions along that line of inquiry on how it is that we think about governing across time in the long-term character of constitutional design. Please join me in welcoming Professor Tom Ginsburg.
Thank you for that very long and generous introduction. It's always a pleasure to be here. I at least am one person who can't complain about the weather. I'm coming from Chicago. It is just a pleasure. Every time I leave the United States, I tell people my blood pressure drops a little bit these days. It's the eve, I think, of the NHL trade deadline. I'm willing to offer you our head of state for yours, and we'll throw in some draft picks for the next 5 years and some cash considerations. No, it's very admirable, actually, where Canada has stood up, and so it really is just a great honor to be here in a free society without being too hyperbolic. What I want to do is talk a little bit about constitutions and the way they govern over time. I'm going to kind of do 2 things at once. I'm going to talk very generally about constitutions, but I'm also going to give a very specific application based on a kind of technical paper I've written recently on transitional provisions in constitutions. And I'll try to put these together in a way that I hope is useful for you, for the undergraduate students. We tend to think in our ideal world, I know some of you have had social contract theory, right? That this imagery dating back to the French Revolution of the people coming together to produce the Constitution, the constituent power, which is evoked sort of in theory once when the social contract is set and creates a structure of governance that's enduring, in principle, forever. And that's certainly the imagery that we have. You have sort of T0, if you will, when we negotiate and come to agreement as a people, and then subsequent periods in which governance just occurs based on those foundational principles. And it's a wonderful imagery. It's a normative imagery. It helps us explain why we are living under this hypothetical social contract. There's been an actual social contract, but why we're living under it. But of course, it's also a deeply false one. Constitutions, as I've learned in these decades of studying them that Jacob referred to, are written in actual history by actual people with actual interests. They are bargained for, they are negotiated, there are aspirations, passions and such, which drive people, ideas, very noble ones. But at the end of the day, they're human creations. And in some of my work, I've shown that they're willfully they're shockingly fragile. I have this large project Jacob referred to, the Comparative Constitutions Project. We've discovered some 900 or 1,000 different constitutional texts for about 220 countries since 1789. Some countries have, of course, disappeared. And that's why the number of countries is so high. But if you just do that math, you realize, wow, each average country's had 5 constitutions. Constitutions do not last very long. And some years ago, I wrote a book in which we calculated that the life expectancy of a national constitution, looking at all countries since 1789, it's only 19 years, one generation, which is just obviously too short to do the things we ask of the text to do. What do we ask the text to do? Provide enduring structure of governance. We ask them to unify a people and create a nation. We ask them to give us aspirations towards which we might achieve, things to move towards as a collectivity. And so you can't do that in 19 years. 19 years is a generation. And so in order to actually achieve the things we want constitutions to do, we should think about how to make constitutions more enduring. And that's what this project's a little bit of a part of. I'll just say as an aside for the students in the room, this 19-year figure that we came up with in our statistical analysis, it uses math, it's a hazard model for those who know statistics, happens to be exactly the same period that Thomas Jefferson, in his writing in the early 19th century, thought should be the optimal duration of a constitution. Because Jefferson, remember, was a radical Democrat, and he thought that the dead should never govern the living. We should always, in every generation, choose our institutions anew. And that meant having laws automatically expire and constitutions automatically expire. And we could, of course, keep the same institutions, but it had to be an act of active choice. So that's kind of a radical democratic take on what constitutions ought to do. I, in the end, have come to the conclusion that Jefferson was wrong. And just to illustrate, imagine some people want to have a new constitutional convention in the United States right now. And we could do it. There's a mechanism in the Constitution in Article 5 which would allow us to have a new convention. I have sort of actively opposed that, notwithstanding all the disastrous, or not disastrous, but pretty bad decisions for our current situation. The constitutional design is way out of date, obviously. We don't use a lot of 18th century technologies in our daily lives. You didn't come here on horses, and you didn't, I didn't write the paper with a feather pen. Yet our Constitution is really, really old. Nevertheless, I wouldn't want to have that conversation again, because of course we'd be fighting about gay marriage and bathrooms and abortion and things which are not solvable problems. So this leads me to explain how constitutions govern over time. And I think it's a kind of a trope in the field of constitutional studies that constitutions are pre-commitment devices. We, the people, limit ourselves in very fundamental ways. We tie our hands in terms of what we can do together, and those limitations actually facilitate our living together and our working together. The limits empower, which is somewhat paradoxical when you say it that way, but when you think about it, it's actually a very fundamental way about how these devices work. In order to govern over time, we have to have certain questions that are off the table. If we could, in every period, every session of the legislature, every day, revisit fundamental questions, well, we'd be spending all our time on fundamental questions and not actually doing the things. And of course, many of those fundamental questions are unsolvable questions. They can't be resolved through negotiation, or they will be conflict generating if we raise them in every period. And so one thing constitutions do is take certain things off the table. I really like the work of James Buchanan on this. Certain things, certain kinds of decisions are amenable to decision by majority rule, and that's fine. Certain kind of things are not. We would want a universal veto, if you will, a unanimity rule. In our world, we call those things rights. If something is a right, that means no one can take it away from me without my permission. And one way to think about constitutional rights, a common way of thinking about it, is that what they're doing is they're taking things off the table so that we can channel our political energy towards solvable problems rather than unsolvable ones. If we were to, in every period, have a discussion about what's the best religion, well, we're going to be fighting with each other a lot because that's something we fundamentally will never be able to agree on. And so by taking that off the table, by having freedom of religion, we empower and channel our energy into solvable problems like how much to spend on the roads and what the military budget should be and things like this. And so that's sort of a generic illustration of how the constraint empowers us as collectivity over time. And that's one thing that constitutional technology, if I can use the term, does. I mentioned before also that constitutions do something else, that they can motivate us. So a common way of thinking about the constitutional text is like as a political operating manual, where it tells us what institutions have what powers and what they have to do and how we know who's the head of state at any one time and such. And that's very important. But it's also the case that constitutions sort of speak to the past and future. They speak to the past sometimes in a preamble, telling us who we are. And this is very common outside, North America. But if you take a generic constitution, you'll find, let's take Iraq, the country of Iraq. If you read their preamble, it's all about the history of Mesopotamia, and it says a lot about who they are, who they conceive of themselves as a people by looking backward. It also will provide some aspirations to motivate us to work towards the future. We aspire to be a democratic society or a socialist democracy or a human rights protecting place or whatever, that those aspirations, which also are very difficult to achieve, putting them in the text can help motivate us and to motivate political action. So that's another way in which this technology is operating over time. Now, what I want to talk about in particular, the kind of particular subject I want to talk about, flows from the idea that constitutions are written in real times and places by real people, and that they are replaced pretty often, fairly often. And most of you will remember that we've had rounds of attempts to refashion societies with constitutional technology, the Arab Spring being a very notable case. Right now, in any particular country, there will be a lot of discussion about constitutional reform, precisely because they die very often, and oftentimes aspiring to better text. Bangladesh is the case at the moment. In a week, there will be an election in Bangladesh in which the public will decide whether to ask their parliament to pass a series of good governance constitutional reforms. And if they do that, there would be a real transition for that country because it's been under a dictator since 2009. Well, that's not an uncommon situation. We together, and as we watch the events in places like Iran and Venezuela, we think, if only these bad people go, we could refashion the society. But to refashion the society requires constitutional reform at a minimum, and sometimes a new constitution. And the thing I want to talk about is how you get from the old constitutional order to the new one. Again, conceptually, we think, we the people in our constituent power, we decide something and then it's off to the races. But that's not how it actually works, because in any historical situation, you're dealing with old institutions, which maybe need to be reformed. You're dealing with new institutions you want to create. You're dealing with governance across time, and maybe even some rights that you want to implement, but those things need time. A very good example would be, let's just say, suppose you have a democratizing constitution, they want to reform criminal procedure. Well, the morning after the revolution, you still have the old policemen, you got the judges and prosecutors, and they're going to be operating under old law, so you need to revise the law. They're also, more importantly, going to be operating under old mentalities. If torture was common, it's really hard to get police not to torture. Every country has. I don't know about Canada. United States, we have a good deal of it. How do you change institutions on the ground to effectuate something like that? It's going to take time. And so what I really want to focus on is this transitional provisions in constitutions, which I sometimes describe as a bridge between the old order and the new order. And a bridge, it's something of it's a narrow bridge. It's not easy to get across. And it's really important to map these steps out in a proper way. And if you fail to transform an institution, to set up a new one, the whole reform project can go off the rails. So instead of thinking about T0 and T1, if you will, constituent power when we draft a constitution and normal governance, which is just going to operate on its own, I'm suggesting we think about that intermediate step. Like there's T0, there's T1, which is the transitional provisions, and then there's T2 and normal governance. And that is what that analytic focus is, I think, important to understand why some constitutional projects fail and some succeed. One way to think about this is that another metaphor that's sometimes used, the constitutions are the rules of the political game. And we all know when we go to play a game, you need rules. You need constraints in order to play the game. All games have constraints and rules. That's what makes them fun and playable. Unlike games we might play, chess or Go or something like that, the rules in the constitutional sense are being produced by people who themselves are players in the future game. And so their interests and their hopes and dreams and maybe even their mistakes could be embedded in that ultimate project, in the game that they're trying to create. And so we have to think about it in that sense and think about can we say anything normative about it? Can we say anything positive about how these transitional provisions are used? All right, let me first say that if you're looking at the architecture of a written constitution, and I have this website called the Constitute Project where anyone can go on and look at all the constitutions of the world. If you were to go on there and look at all the extant constitutions and type in transitional provisions, show me the transitional provisions, you'd find almost 80% of constitutions have a separate section at the end that is on transitional provisions. How do we get from the old order to the new? And I'll tell you a little bit about the kinds of questions that they have to answer. But the one thing I'd say about that is I also know from working with constitution makers that these provisions tend to be drafted at the very end. You spend all your time negotiating over the structure of government and which rights you're going to include, a ton of time about the symbolic stuff in the preamble. That's really occupies a lot of actual constitutional drafters' time. Are we an Islamic nation, or what's the status of Islamic law, or are we pluralist? People fight all about these kind of symbolic things, and maybe I'm not going to say that's not important, but from the point of view of an operating manual, it might not be as important. The big point is that when it comes to thinking about how do we get from here to there, there's very little thinking that goes on, very little writing, very little guidance, if you will, for how one would think about this systematically. I'm going to give you, and I'll give you just an example to illustrate what I'm talking about. The United States Constitution has a couple of transitional provisions. One is very typical. It says the Constitution will come into force when 9 out of the 13 states ratify it. Okay, that's a critical thing. We have to know what is the date, the focal point on which we're going to move from legal order 1 to legal order 2. And so a constitution that doesn't do that is creating a new round of uncertainty, a new set of issues to fight about if you're not clear about it. It's an illustration that sometimes the most important provisions in constitutions are not big important things, but very small things without which we can't move forward. Who is going to chair the first session of the legislature? If you don't say that and the legislature gets elected and meets, well, how are they going to figure it out? You can let them figure it out themselves, but on the basis of what voting rule? And who gets to make the proposal and such? It's a kind of very little thing, which, and I usually, if I'm in advice-giving situations, just pick the oldest person there, because it's a clear rule. And in most societies, that person's going to be respected. And so, at least then you're off starting. But if you don't say anything, you're inviting conflict over something very small that could have been resolved very easily. So the Constitution should sometimes include very, very small things. But the date in which the thing comes into force is very important. The other thing the United States Constitution did was it set a period, 19 years, again, during which Congress could not ban the international slave trade. Now that's a moral abomination. They should have obviously abolished the slave trade and slavery in the Constitution. They couldn't do that. And they were bargaining. And so this is what they came up with. It said, okay, you Southerners, you can continue your practice for this period, and then we have the possibility of overturning it. So you have your practice for a certain amount of time, and then it can end. And it did, in fact, end on the very day that it was allowed to end. That's a transitional provision. It's a good illustration. It's a provision that by its own terms will end, with its legal effect will end. It will then may stay in the text, but it's kind of an archival thing. It's not, doesn't have any operative force going forward. Whereas a provision on elections or on rights, those are going forward forever. So that's what I mean by a transitional provision. And sometimes these can be very important. I'm going to tell you a story of a small African country, the Gambia, where they had this dictator for 19 years or so, who fled in 2017, Yahya Jammeh. And Jammeh governed under a constitution in which there were no term limits. Term limits, another very important provision in constitutions which regulate time. I'm working on a book on that. I could talk about it all day long, so I'm not going to get distracted, but term limits are super important. In this case, Jammeh didn't have term limits, and so when he was kicked out of power and he fled, everyone agreed we need a new constitution with term limits. We can't have people who are there forever. And they underwent a model constitution-making process. A commission was formed with a very significant Gambian lawyer. They traveled to every part of the country. And I followed this very closely. Some of the places they went, the people said, you're the first person we've ever seen from the central government. And you're asking us what our constitution should have? You know, it's a good thing to do. You want to get people's input before some fundamental decision. They wrote an excellent draft, technically. In their transitional provision, they said, you know, we're going to have a 2-term limit in the Constitution. And by the way, the president who had been elected after this dictator, the term in which he's currently sitting, that's going to count for 1. Okay, so just to be clear, Constitution is going to enter into force, but this guy can only have 1 other term under the new Constitution. Doesn't seem particularly controversial when you say it that way, but in actual Gambian politics, that was fatal. And they've tried now 2 times over 5 years to have the parliament adopt this thing, and it can't get through because the president's supporters want him to have at least a 3rd term. That's what he says. And so there's an illustration of how these transitional provisions, I mean, I think they took this step very consciously. They knew what they were doing. But in the context of actual really important interests, can actually derail a whole good government constitutional project. That's what happened in the Gambia. So they matter. Why do we need them? What kinds of topics do they have? Well, obviously, if you have old institutions you're trying to get rid of, a junta or a council, you want to fade those, you have those sunset. You also sometimes need to set up new institutions, a Human Rights Commission, an ombudsman, a counter-corruption commission. How does that first version of that get formed? What do you do about legality? Old laws, do they continue to remain in force? Many British colonies, probably, I don't know enough about Canadian constitutional history, so I'm not even going to go there, but many other former British colonies would have what's called a savings clause, where old laws explicitly are allowed to remain in force under the new constitution. In other words, it's not really legal ground zero, or everything is, to avoid it being seen as legal ground zero, where we have to repass every bit of legislation every time we adopt a new constitution, use a savings clause. The old laws will come into force. What about legal cases? We have a lawsuit pending in the courts, and all of a sudden there's a new constitution. What happens to that? You've got to answer that question. It's a technical one, but much could turn on it. What to do about oaths? This is another thing we tend not to think of as being very important. But, you know, oaths matter a lot, more than we think, to politicians. And so you're going to adopt a new constitution. You might want people to take an oath to the new constitution so that they're fulfilling the new one and not the old one. Well, you know, if you leave that out, they might say, no, my duty's to the old one. And you could get into all kinds of problems. One interesting thing we've seen is creating monitors for the implementation of new laws. And so you might say, and I'm going to spend a lot more time on this, with this, you know, after the Constitution is adopted, the legislature has to adopt laws A, B, and C to set up these new institutions to do this and that. And you could say that in a text. But how do you make sure that the legislature that gets elected actually does that? One interesting model in Kenya was they set up a commission on the implementation of the Constitution. So it was supposed to watch every step that was listed in that text, had an actual body with a staff that was going to report on what was happening and how the implementation was going. That's not used very often. It was a good model. Because otherwise there's always the risk that as political attention fades, as agency problems rise, when politicians get in, that the things don't get implemented. And I'm going to list one other thing which we've seen in some cases very interesting, which is mandatory review of the Constitution. Remember, in the real world, we're bargaining and negotiating with a lot of uncertainty. We don't know what's going to happen. We don't know the state of the world. We, comparative politics people, don't even have very good guidance on we don't have guidance on universally best institutions. You can't say that federalism is great for everybody, or presidentialism or parliamentarism or anything like that. Even those fundamental things, there's no best practices. Everything must be situated in its local context. So that means there's a lot of uncertainty about how the thing will actually operate and what it will do. And that uncertainty is inherent in the project, but it does mean that you have to be very careful, I suppose. And one notion which has emerged is that, okay, because we're uncertain, we're going to have a review of this in a few years. We're going to just take a look again. How did that work out? In a very famous example, in Brazil, they were in 1988, they were fighting very bitterly over whether the country should be parliamentary or presidential. And everyone thought it was going to be a parliamentary system. And at the last minute, the presidentialist faction, won in the votes of the Constituent Assembly. But to ease the pain of the losers, they said, okay, that's fine. We're going to be presidential. But you know what? Let's revisit this in 5 years. We'll have a public referendum on the nature of the political system. And they indeed did in 1993. And that referendum asked whether Brazil should be presidential, parliamentary, or a monarchy, actually, which Brazil had been in the 19th century. Hey, put it on the table. Let the people decide. It's a nice use of it's kind of good for a bargaining technique to help say, we're really not certain, and we're going to let the people revisit. In fact, of course, in that case and in many others, people don't really want to change the systems they're accustomed to, so presidentialism won handily. But the point is that mandatory review and a mandatory vote kind of helped. It was a useful transitional provision. And of course, it faded after that 1993 moment. All right. My main claim in this paper I've been working on is got to do with what determines the scope of delegation to the future in these constitutional settings. What do I mean by that? Again, imagine we're a constituent assembly for a country and we're negotiating things, and we might have our different political factions. And we're trying to think, well, how much do we decide now and how much do we leave to the future? And in particular, what kinds of things are we going to put in the transitional provisions? How tightly are we going to govern that intermediate phase? That's kind of the positive social science question I want to ask. And I answer that basically there's two really important factors. One has to do with the absolute level of change that we're contemplating. Right? If you're moving from a dictatorship to a democracy, you got to change a lot of things. If you're making more moderate changes, then then you might need less. There would be less uncertainty and things like that. But the other factor, I think, has to do with political uncertainty and trust. And I'm just going to provide two examples of countries in Africa which illustrate very different constitution-making situations. So most people in comparative constitutional law are very familiar with the South African case. Bad apartheid regime, negotiated deal for a peaceful transition, very successful in that regard. And they used an interim constitution. They finally got a constitution in 1996. What was the level of trust and uncertainty among the drafters of the Constitution about the future decision makers? That's the question I want to ask. And in that case, there was no doubt whatsoever which party was going to win the elections. It was going to be the Liberation Party of the African National Congress. No one had any suspicion about that. And the minority negotiated rights and things like that to protect their interests, but no one was uncertain. There was no uncertainty. Not only that, because the ANC was the major force in drafting, there was a good deal of trust that they had in the future drafters. And in that kind of situation, I would expect, and I would argue we find, relatively few transitional provisions that constrain that intermediate actor, that constrain the implementation of the Constitution. No, the ANC's writing the Constitution. ANC knows it's going to implement it in normal politics. So the bridge becomes less important, and it's not very constrained. They trust themselves to do the right thing, and so we don't see a lot of those kind of provisions. In Kenya, in 2009, in their second attempt to try to make a constitution, the situation was very different. And I won't go on too much of a digression of recent Kenyan history, but this constitution was being drafted in a process whereby the drafters was a technical commission, which included some experts from outside Kenya. And they were going to draft the thing and then deliver it to Parliament to adopt and to implement. I don't want to be too hyperbolic, but Kenya's parliamentary politicians might be the most venal in the world. I mean, they're Donald Trump level venality. It's really bad, very corrupt. And so the people drafting this, technical experts and civil society, which was wanted a new Kenya to refound the country, they didn't really trust the actual implementers in the end. And so what they did is they created all kinds of constraints in the transitional provisions and all kinds of limits, if you will, on what they could do. And they did two innovations. One was the commission to implement the Constitution, which I just mentioned. But then they also, because they really didn't trust the Parliament, said, if in the Constitution, if Parliament doesn't pass these laws by these dates, it will be disbanded. And that actually worked. The Parliament did pass a lot of laws. So, you know, I'm not saying they were the best laws, but they did their work. So that's a good story of how there's a good deal of certainty on who's going to govern, but no trust between the drafters and the implementers. A third kind of situation would be maybe something like Brazil, which I mentioned before, which was undergoing a major political transition, but they had the military had ruled before. They had a very, very open constitution-making process, a chaotic constituent assembly. If I had a PowerPoint, I would show you pictures of the fistfights that had broken out in the Brazilian Constituent Assembly. Now, so what is this? They knew they wanted a democratic country. No political force in that fragmented environment could predict that it would be governing. That means there's a lot of uncertainty. And also a lot of no trust, because how can you trust someone you don't know who's going to be there? And so the Brazilian Constitution, if you read it today, it's one of the world's longest. It's got all kinds of provisions which try to constrain this bridge period. And some of them are things we would not expect to make it into a constitution. The number of days of paternity leave until the legislature passes a law on paternity leave. The percent of the local budgets that have to go to the civil service. Like things we would think of as ordinary politics. And they put them in there in the transitional provisions because they didn't trust the future. They also used another technique, which I think is a very interesting one, which is to say, not just to leave open-ended realms of governance open, but to say, legislature, you have to pass a law on this, 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 and this. We think there should be the interest rate. They actually constitutionalized the interest rate. The interest rate should be no more than 10%, and Parliament should pass a law on that. Anyone who knows some basic economics knows that's absolutely nuts, and Parliament never actually passed the law. But the idea was that, okay, we really don't trust these people. We're going to have a lot of things like that, a lot of bylaw clauses. By some counts, 350 different acts were required after the Brazilian Constitution was adopted. And by other counts, at least 150 of these have never been passed. So they didn't actually constrain, but they tried. They tried to control the future. And the result is quite a long and messy constitution. I'm going to provide one more situation, one more example of this dynamic. And it's a less pleasant one. It concerns Augusto Pinochet in Chile, the Chilean dictator. But the same dynamics, I would argue, about certainty and trust were very important in that constitution-making process, which was completed in 1980, and Chile's subsequent successful transition to democracy. And this gets in a little bit to the kind of a side point I want to make, which is that we tend to think constitutions in dictatorships are just window dressing and things like that. Not true. They matter. And they mattered in that case very, very, very much. Pinochet was trying to have a constitution that would transition to civilian rule, but would take a lot of things off the table. Things like property rights and neoliberal governance and the central bank and other things, and sort of locking in a political power for his conservative constituency, which apparently worked because they're now governing Chile as of the recent election. Okay, so here's a dictator. He knows he's going to go away. He wants to pass power to the civilians, but he wants to do it in a limited way. And he adopts a constitution with a long transition, 8-year period when he would continue to govern, and then there would be an election in which he would run, and presuming he thought he would win, he would just then implement things as the civilian head of state. And as time grew closer, actually, Pinochet realized that I might not win this thing. And so let's postpone that election. And his own constitutional court, this is in a military dictatorship, said, no, you got to have that election. And they had the election and he lost. But the big point is that the Constitution had so many sort of guarantees for his side, an electoral system which is very biased towards the right, which they've subsequently gotten rid of after a long time, amnesties, positions of senator for life for him and his friends. Those are transitional provisions. They're basically saying we are going to have, our political life is going to outlast our actual position in power. And I leave it, maybe I shouldn't say much about it. On balance, Chile's a much better place. It moved very slowly and too slow for many, many people. But, maybe gradualism in a kind of Burkean sense is a good thing sometimes because, institutions could adjust. You didn't have the radical left-right swings we've seen in many other Latin American countries. And at the end, those amnesties faded away and reforms have occurred and Chile has moved on. So that's maybe in my view, an optimistic story about how transitional provisions can facilitate good governance in some occasions. All right, so the positive claim I'm making is that, this uncertainty and trust is what would predict in national constitutions what we would see. I want to say a few normative things, though, if I might. So, first of all, as I said before, I've learned that these are drafted at the very end of the process. Everyone's exhausted, they've been negotiating all kinds of things, and then someone says, okay, we got to do the transitional provisions. They don't receive as much attention as they should. And that provides some opportunities for some strategic behavior, I guess would be how we would say it politely. And a good example might be in Egypt during the Arab Spring. You may recall Mubarak leaves, and then there was a lot of chaos, and eventually the Muslim Brotherhood took power and was drafting a constitution. They did draft a constitution that was adopted and was enforced for a couple of years. In the transitional provisions, they put something that said, of course we've talked all about Islam in this constitution. What we mean by Islam is Sunni Islam. It's not well known, there's almost 1 million Shia in Egypt, so they're now totally excluded. So that's not what we would ideally like to see in an enduring constitution. It didn't last very long, of course, because it's been replaced by a military coup. So that's the kind of thing which shouldn't go in. What we would want is truly to limit these things to those kind of issues for which there is a true bridge that must be crossed. And that I think would allow us to go through transitional and say, no, that's not a good one, that's a good one. Keep these things out of this section. This should be preserved only for the bridge questions, and should, in particular, we have to guard against interest group bargains that come in at the last minute. And interest groups are pervasive in this process. As I've written in other work, you're never going to get interest groups out of constitutional design and implementation, and to some degree, a little bit of interest group activity might even be good. In our study of what makes constitutions endure, we find that very long constitutions, with lots of detail, that are amended very frequently, are actually enduring. They last a lot longer. And my theory for that is that you have a lot of interest groups that got something in the Constitution, they really care about it. And that might be good when some radical force, maybe a populist president, comes along and says, you know, we got to start over. These institutions aren't where it's all screwed up. I've got to run, we got to have the Trump Constitution or something. Well, there's too many interests, too many people who benefit too much from the status quo to let that happen. And so that suggests like the optimal amount of interest group activity is not zero, even though I think public choice theorists and so forth, you know, say, well, no, the job should be to minimize that. I think you want to optimize it. But all that said, is, you know, I do think the critical thing for transitional provisions is to keep them clean of a lot of that kind of thing, to the extent you can. Well, I will say, I'll just say, conclude by talking a little bit about what, again, the job is here of constitution making. You know, again, in contrast with the image that we are going to come together, that we are one people unified that creates these rules, we're always divided, we're always fighting, we're always bargaining, we're always negotiating. What you want are rules that allow parties to negotiate with each other in an ongoing way, that discourage them from escalating, as we are seeing in my country now, escalating, making everything about executive power and such. That's not a way to sustain a democracy. And so if transitional provisions are well drafted, they will help us get there. But if not, they might end up recreating the very problem that the constitution making was supposed to solve. And I return to the Gambia. The current president of Gambia was a Democrat. He was elected because the last guy was a dictator. He said, I'm only going to stay for 2 terms. But this fight over the Constitution means that maybe that's not going to happen. I can't tell you how many cases of elected Democrats come in and try to outstay. In fact, just to report on that, a statistic there, I've looked at all fixed-term presidents since 1789, all presidents who had a limit. And of those who get to the end of their limit, which would be Obama, but not the first George Bush, right? They serve the maximum. 25% of those people try to stay on around the world, and their batting average is about 80%. It's a huge problem for democratic governance, and it's a huge problem for governing over time. Again, just to conclude on this point, a well-crafted constitution is going to incentivize rotation in office so that we're focused on the institutions and not the individuals. And I think that applies to the transitional provisions as well. Think about the institutional stuff and not about the particular characters who happen to be operating the institutions at any one moment. Okay, I think I might have gone a little over my time, but I think I'll stop here and see what you guys have to say. Thank you.
All right, at these events, the first question goes to a member of the RGCS Charles Taylor Fellowship.
And if you could introduce yourself, I'd appreciate it.
Yeah, I'm an undergrad in philosophy and political science. I'm Huang, and I have a question. This is somewhat related to Robert Meister, a theorist at UC Santa Cruz. His research on transitional periods. The first question I have is, what about the status of the victims in some regions that you say are unsolvable problems? For example, for ex-slaves in U.S. constitutions, what happened during the 20 years period? If they want to raise that issue again, what will be their status? For example, somebody like Winnie Mandela's, Nelson Mandela's wife during that period, the transitional period. And a second question, I hope that's also related to the first, is that there's kind of a difference in saying that it's an issue we cannot solve in this 20 years period, and we should put aside for it to be decided later. And kind of transition to say, well, there's a goal that everybody can agree that we're striving towards, but we cannot achieve it now. So we leave it so we can gradually transition and decide it later. So for example, in like Stalinist or like Leninist regimes, they have that theory, they have that kind of constitution. But also West Germany, when the issue of like what we do with the Nazis rose up, I wonder what you think of the status of like people before the constitution when you decide a problem as unsolvable or not to be solved now.
Okay, great question. So a good general question. And what I would say is I didn't mention this, and I should have, so I appreciate the correction. Like, one of the topics that transitional provisions often will deal with in major changes is transitional justice. We're going to set up a commission to examine the transitional justice and things like that. Oftentimes the details and the diversity of approaches to transitional justice is so great they don't decide the actual mechanism. But they say there will be a commission in order to deal with the past. That's very important in speaking both to the past and future, right? You're speaking because you acknowledge that there in fact are people who have suffered, who should get some reparations. In the United States, we've never done that, as you may know. Even with the 14th Amendment, which, when slavery ended and we had the civil rights thing, we did an attempt. We created an administrative agency to help the freed slaves. But the political will ran out very quickly. So this is a good example of how, I think your point is a good one. In an ideal world, in my world, if I could go back, I would have said in the 14th Amendment, they should have constitutionalized the Freedmen's Bureau. That would have been better. They should have put something in there. There's going to be a Freedmen's Bureau. It's going to operate this long. This is what it's going to do, and everyone has to cooperate with it. Because when political will changed with the election of 1878, it was just gone. And it's also an illustration, to go to your question about the slavery situation, the provision about the slave trade. We should always be careful about, and this is, maybe it's not such a controversial thing to say as it would have been when I was your age as a student, but the world doesn't move towards progress all the time. Some things get worse by not being resolved. And in particular, slavery in the United States got much worse in the 19th century. And the legal position of black people, many could vote at the time of the Revolution and the Constitution. In many states, they lost that right in the early 19th century. So that's a point for saying certain moral things, and from a normative sense, should be dealt with because they don't get better. They're not going to solve themselves without using the political will at that critical time.
Hi, thank you so much for the lecture. My name's Maddie. I'm an undergraduate in philosophy, political science, and gender studies, and I'm also one of the fellows. My question is just clarificatory. So for your positive claim or hypothesis that uncertainty and trust can predict what we see in constitutional transitional provisions, I'm just wondering what the scope of and definition of political trust is here. What I got from the talk was more or less trust is measured as trust in constitutional implementation and implementation of transitional provisions, but I'm wondering if your goal is to expand the definition of political trust as well to something beyond that.
Yeah, trust is a big and complicated word, as you know, and I don't really mean it in any deep sense. The way I think about it is that, you have an enacting coalition of a text or any legal document, and then you have an implementing coalition. And in cases where those are the same, African National Congress in South Africa, there's high trust. So that's all I mean by it, and in that case there's identity among them, but it could be that there was a different actor, but they were on the same political team or close set of trust. So that's all I mean by it.
Hi, thank you so much for this really interesting talk. Connor MacDonald, I'm a 2L at the law school here. You've spoken about transitional arrangements and their importance to democratic culture. I kind of wanted to ask you about, in some ways, the opposite kind of clause, which is something that seems on its face to be quite innocuous, but you end up in a democratic system hanging quite a lot on it. So in the Canadian Constitution, we have something called Section 96. All that says is that the federal government is able to appoint the Superior Court justices into our kind of superior courts. But that's become, over 150 years, a clause that's been used to justify judicial independence. It gives them a core jurisdiction that can't be taken away by the federal or provincial governments. And no one thought it was going to do this when the Constitution was first passed. And I suppose my question is, when you go about advising other constitutions, how do you think about these clauses that to everyone might seem innocuous, but might end up be doing quite a bit of work in democratic culture more generally? And then I have a second, more provocative question that you don't actually have to answer, which is, you said at one point in your talk, we don't really know the best practice between a parliamentary and a presidential system of government.
Ouch.
Really? Is that really?
Yeah, nice. Good. All right, let me. I'll actually comment. I'll just report the social science research on the latter question. You know, there's a very famous debate. Those of us who studied comparative politics in the 1990s, there's a huge debate. Juan Lin's, presidentialism's bad. It's winner take all and all this stuff. And then, as the research went on, it became a little more sophisticated. We learned that parliamentary systems tend to have larger budgets, more pork barrel stuff. You have some disastrous parliamentary systems like Israel, where small parties run everything. In the backsliding era, we have Viktor Orban, as well as Donald Trump. We have in a semi-presidential Poland. So, it depends what you're trying to solve. My friend Jose Chebub is a political scientist who wrote a wonderful book where he shows that Lin's claim that presidential systems died more frequently was attributable to selection effects and not to the actual presidential system. That's what he claimed, and so I believe that. It's very hard to, if you show up somewhere which has been presidential for a long, long time, like Brazil or anywhere in Latin America, and you say, we really think you should try parliamentarism. People don't want to. They don't want to experiment too much with constitutions. They might experiment with a, ombudsman or some smaller institution, but these core things of political identity, who people look up to, it's very hard to change that. My own view, when I'm sometimes asked what's the best best constitutional system, I just say Germany. It's a parliamentary system, it's a federal system, but I think you could make the claim, now that I'm thinking a lot about term limits and executive tenure, someone like Angela Merkel probably served 4 or 5 years too long. They become the go-to person that, the same thing that we worry about and why we have term limits, they don't have. We're now seeing a trend in constitutional design, a couple of countries which are proposing term limits for prime ministers, which is a very interesting thing. So that's a long aside on that. In terms of provisions and advice, yes, you never know what's going to be significant. And you also, it's very hard as an outsider to know what the local, pitfalls may be. And I've just seen some really wacky things happen. I did a lot of work in the Constitution of Mongolia when I was young, and they just adopted this weird system as a result of a political compromise, by which the prime minister proposes the cabinet, the president approves it, and then he never has to go to the parliament. Strange. So where's the accountability at all? And this was like they're just jerry-rigging something. Who would have seen that coming? Their constitutional court interpreted some provisions in to me, very strange ways. So basically the job of an advisor in a situation like this is like the job of a lawyer advising a client. What's the job of a lawyer advising a client in a contract? Look for the pitfalls, and ask questions. Well, what happens if this happens? And did you anticipate this and that? And you can help people in that sense, in the sense that because comparative experience is relevant. Every situation is unique, but every situation has analogs, and so bringing that knowledge to bear can be helpful. But ultimately, is extremely hard to predict what's going to be the provision that blows the thing up. And yes, I have a number of examples of that, of just very strange interpretations in very partisan ways that ended up creating gridlock.
While the microphone's up here, we'll go to Amy, and then it'll go back to David and Ethan.
Hi there. My name is Saul. Thank you for your talk. And I'll pass it to Amy right afterwards, I promise. So I think my question actually will follow on quite nicely from your last answer there. I'm curious about the length of these provisions, provisional provisions in the constitutions. Firstly, I guess, what are the factors that affect the length of these provisions in constitutions similar? Like, these are the same factors that you're identifying in your project. Yeah. And my question is also motivated by kind of my own work and this idea that if we take the claim of certain theorists like Hartmut Rosa and William Schurman, liberal kind of legal theorist, that the social world, the political world is changing more and more frequently. Should we expect to see these provisions last longer, last less long? I can think of kind of some good reasons for both possibilities, but I want to hear what you have to say about this.
Yes. Constitutional lifespans, I wrote this book in 2009, we thought they might be getting shorter, but now I don't think that's true. I don't know. I want to redo that analysis and see. We certainly have many examples of countries which have continued to churn through and fail to find enduring institutional solutions. And that could, in part, be, I'm not sure I would attribute it to the rapid change of the world, because the text, we're bumbling along in the United States with this ancient text, and we're also the leader in AI and all kinds of things. Like you can kind of work around it if the political will is there. So the texts aren't very binding in that sense. But what's necessary, of course, is interpretation. And this gets to your first question. Like, you've got to interpret these things in a kind of reasonable and living constitutional way, if I could put it that way. I mean, I guess it's actually related to that question. Like, if you treat these things as too rigid, then they will become pitfalls and barriers. Now, you asked in my study if I was looking at about the length of transitional provisions, and I should have made clear, I'm adopting in my actual study a functional and not a nominal definition. So in any constitution, you go look and you'll find all these transitional provisions. Sometimes there are things like the Egyptian example. These people were out, these people were in. Well, that's not a transitional provision. That's a substantive exclusion that you slipped in there, at the last minute for reasons related to the bargaining. And by contrast, the U.S. provision on the slave trade is not in some section called transitional provision. So I don't really have, based on that approach, I don't have a methodical way to say how long they are. I could and can find, like, are those sections getting longer and longer? They're certainly getting more frequent, and that might be some indication.
Hi, I'm Amy. I'm an undergrad political science and art history. So I'm going to do my best to read my handwriting. I apologize.
Oh, I have that problem too.
So the first question I had like kind of two, if that's all right. The first question I had was about, like, you mentioned the interim constitution in South Africa, and Jefferson's idea of, like, there needing to be a sort of like a necessary time limit on constitutions. And I was wondering about the potential merit of interim constitutions generally, maybe not instead of interim provisions, but like as a sort of just a facilitator in that, and what your thoughts might be on constitutions generally having like a time limit. The second question was generally, what is constitutional, like, what is the health of a constitution? Is it and I apologize if you have already mentioned this, but just for clarification, is it generally like its ability to be passed and to to be long-standing, or is it like what you mentioned with its adaptability and its ability to facilitate disagreement? And generally, what are the political functions external to the Constitution itself that might lead to the Constitution's like failure? Like, how much can we attribute to the Constitution versus its general political circumstances?
Okay, I'll take those in reverse order. So in this book that I was referring to, we look at the question. So obviously, if you think about it, you could analogize to the human body. And by the way, we use the term constitution for the body. It's helpful. Like, say a pandemic hypothetically comes. If I'm a person with a strong constitution, I might survive something that other people would not, right? So there's something, there might be something in your host, if you will, which matters. There certainly are environmental factors which matter. Generally speaking, a pandemic's going to kill some people, so there's external things. And then the real core question is there anything in control of constitutional drafters or constitution makers that can help that constitution to survive in a particular state, a particular body? And what we found that, factors, lots of factors matter in all three categories, but when it came to things in the control of drafters, we found that constitutions that were produced in a more inclusive way, that brought together the major social groups, didn't exclude any major social group in the society, constitutions that were more flexible, that makes a lot of sense, just like people who do yoga probably live longer. You're just able to adjust to changing circumstances as they happen. But then also ones that were more detailed. So the U.S. is an outlier, actually, in this regard. And again, I think the logic there is something like when I was talking about interest groups. Like if you have a detailed constitution that gets amended a lot, people care about it, it's in their mind, interest groups care about it, it's going to help it to survive. It's vital. It's getting worked very regularly. If you have one that's impossible to amend, like the U.S. Constitution, and it's interpreted in a biblical way, not in a flexible way, that's not actually a good general advice for how to survive. So you might say, well, what about the United States? What explains it? In our book, we analogize it to the oldest woman ever to live, a woman named Jeanne Calment, who was a French woman who died at the age of 122. I think she died in 1997. Incredible. And there's a birth certificate. So they went to her and they said, what was your secret? How'd you live so long? She said, I smoked till I was 117 years old. And then I quit, and then I didn't feel better, so I went back to that. I went back to this point. So, I drank. Her diet was something like port wine and olive oil, and chocolate. Like, okay, strange diet, not normal food. So the point is, like, whatever that was, it might have worked for her, but it's not general advice. Don't try that at home. Don't smoke till you're 117 years old. And similarly, the United States Constitution, like, I would never recommend it as a model for anything. And I've seen people who do, and it's just, obviously it's, barely working for us. We'll find out. But it's certainly not something that one would want to emulate because, again, just think about it as a technology. Technology is always changing. There's innovations that happen all the time, including in governance. I mentioned an ombudsman or a human rights commission or a right to information. These things get invented by someone and tried out, and successful ones get borrowed. So there's a real cost to us from not updating our text. Your first question, it was about interim texts. And so we do have, of course, oftentimes in the line between constitutions and peace treaties is a thin one in many settings. And sometimes peace treaties will call for an interim constitution, South Sudan, or a permanent constitution-making process. And there's a lot one could say. I think, again, you don't want to overload those interim documents. And the reason is, and this has happened in South Sudan, if the interim document is sort of too complete, the people in power, which is basically one faction in South Sudan, might never take the required step of producing a final constitution. So in that constitution, there's a constitution-making body. I did a little work with it once. Basically, the incentive of Salva Kiir, the president, was, I want this body to be as big as possible so I can hand out as many government jobs using foreign money as possible. And that's what's happened, and they've never gotten around to it. So, sometimes it's necessary. South Africa's the paradigm case, and it worked out very well. But it's oftentimes a kind of substitute solution. The only good thing about it is it does lower the stakes of the bargaining, because the opponents will say, well, we are going to have another chance. In that sense, the psychology of governing over time gets invoked in that way. So I think that's useful. The final thing I wanted to say in response to your question was that, the idea of reviewing the Constitution every period, Jefferson's idea has actually been implemented in American states. I think 14 American states have a constitutional rule that says every 20 years we're going to ask the people in a referendum if they want to have a new constitution. And every 20 years it appears on the ballot, and every once in a while, state, Georgia, I think, has had 7 of these, if I remember, they draft a new constitution. But that's not really quite the same thing because states are not countries. The stakes are much lower. So we use the term constitution. I don't think it's quite the same thing.
Pass back to David.
Hello, Professor. Thank you so much for the talk. My name is David, and I'm an undergraduate student in political science and philosophy. I'm also a student fellow of the RGCS. So my question is kind of related to Maddie's question. And for the last bit, I've been working on a project on political trust and distrust. And the key question in the literature right now is what kind of attitudes we should hold towards democratic safeguards, and which of those include the Constitution. And in particular, so the debate is either if the political distrust we have actually encouraged and normatively justified, like the Constitution, or if it's merely like a check and balance tool that we rely on so that we can establish political trust in the institution. And then, so when you said like the Constitution, what I wrote in my notes is that like it kind of like take things away from the table, so we channel our energy into solvable problems. The constraints basically empower us to focus our energy, and that seems very related to the literature right now. But at the same time, I was curious, if it takes things away from the table, would we really have like would our attitude really be trusting towards it? Or it seems more like the accurate attitude would be a more distrustful one, particularly because the Constitution is so normatively charged. So just curious about what you would say to that. Thank you.
There's a lot there. I mean, again, I don't have a deep, in this project, I'm not invoking that sort of deeper idea of trust. You're talking about trust in institutions. And I think one thing that your question reminds us of is the optimal level of trust is not 100%, right? You need in a democratic society a certain level of mistrust, but the optimal level of trust is also not zero. And where we are in many industrial democracies is maybe getting a little low on the trust in institutions. I think that as you were talking, I was thinking about term limits. Okay, so what's a term limit? A term limit says to the people, you can't elect Barack Obama again even if you want to. And you can't elect Donald Trump a third time. And for many people, that's experienced as anti-democratic. But it's an institution that, in some sense, is designed to foster longer-term trust in the system as a whole. So I guess what I'd ask you, or ask about the literature, is it distinguishing among trust in specific institutions at this point in time, or system trust about the operation of the system as a whole? And that's quite distinct from what I was talking about, which is trust in the particular actors. So just to be analytically clear about that. I don't know if you want to respond, you can, since you seem to.
So I think the literature is so we have a lot of literature on political trust, but when we started considering political distrust, not merely as like a lack of trust, but rather as this more like a moral condemnation, particularly on the failure, that established distrust. And then we have this other attitude that we're slowly starting to introduce called mistrust as well, to now have three parts. And then so for the distrust, I think it was a little ambiguous, where it talks about it, how it's like it can be either targeted towards the institution, whether in its parts or its entirety. It can be like intermediary organizations. It can be the laws or whatnot. But a big question though is like, what should the attitude we hold towards the institutions like Constitution be? Particularly because if we say we distrust it, it seems to have like this other consequence. But if we trust it, then we're wondering if we're blindly trusting it too much.
Mm-hmm. Okay, thank you.
Hi there. My name's Ethan. I'm a member of the RGCS Fellowship. I'm also a philosophy student here at McGill. So I have two questions. The one is a bit more contemporary, and the latter is a bit older. So for the first question, you spoke a little bit about monitoring, and I'm interested in the relationship between how you describe, I guess, the keys of power in this situation, the divisions that we create in the Constitution and the constraints we apply, and enforcement. I know currently in the United States, there's a real question that many legal pundits have brought up about, specifically with regard to the tariff cases, but many cases that have surrounded the Trump administration, of even if the Supreme Court enacts a certain ruling, whether or not someone like Trump will just call their bluff and say, I'm not going to abide by it. And because there is essentially no precedent in the United States of, well, who's going to arrest the president? How are we going to enforce this? How is it that constitutions can build in enforcement mechanisms, especially when those interests, as you've described, are naturally laden in different political factions and what those actors want to bargain for and achieve? Second question is about a specific case. So I personally think that the U.S. Marshall Plan was one example of a very, very successful constitutional transition. But when we talk about the U.S. Marshall Plan, what we find is that there's sort of an inherent tension, which is that you have a foreign actor that is rebuilding a nation that it has just won a war against, but is also now has unilateral control over any amendments to the Constitution or any laws that are passed for that matter, has actively pushed against factions that it deems to be too extreme, namely the communists, but many liberal factions in general. And in the case of Japan, what we see is that downstream we have a very stable democratic society, but the foothold of the LDP has essentially remained intact for decades. So I wanted to know if you could talk a little bit about the relationship between these kinds of transitions in nations where there's an asymmetric power divide. I think that also probably especially speaks to the process of decolonialization and independence in many nations.
Okay, there's a lot there. Let me start on the enforcement question. In the literature, we tend to focus on this idea that it's a kind of David Humean idea that there's no outside actor who's going to enforce the Constitution. It's all within the system. And so the term that's used is self-enforcing. It has to be a self-enforcing bargain. And indeed, that's what James Madison thought he was doing by creating these different bodies that would check each other, let ambition counteract ambition. At the end of the day, what is the mechanism? This is Barry Weingast, 1997. Ultimately, it's all of us coming out in the streets. And that's what happened in Minnesota. That was constitutional enforcement. If the citizens of Minnesota hadn't had a general strike and all that, and I'm not implying that anyone's out of the weeds, but that's a really important mechanism when government is shameless and authoritarian. So that's ultimately how things get enforced. Now, in the shadow of that, political institutions are acting. The Supreme Court currently is, I hate to break it to you, not doing a great job. And that's because of its composition. It was captured, essentially, but with the help of Mitch McConnell. They basically packed the court, is the way I would use the term. And the lower courts are still doing pretty well, honestly. And even some Trump-appointed judges are ruling against them because they're so outrageous and egregious. But the Supreme Court is terrible. In an ideal world, the Supreme Court is going to be calculating what's likely to happen. And in the tariff case, this is no doubt what's going on, I think. First of all, as a legal matter, I taught administrative law a couple years ago, I cannot see any way, given the doctrines they've created, they could uphold the tariff power. They're the ones who created the major questions doctrine. You can't just say, oh, in this case, the president wins. I don't know what legal gymnastics Sam Alito could do to make that happen. I just don't see it. So then the question is, well, now you could tell that they're in this period of well, God, we don't want to do it now. It's this fraught period of foreign relations, that we don't want to hurt the president. He's going to have to pay back all this money to the Canadians, And so they're doing some political calculus about when to release the decision. That's my best guess, but again, I don't know. They could do anything. And that is always done in the shadow of what they think the response is going to be. And so that means that they're obviously a political actor, and we don't know what the response is going to be. There is something which might end up saving us, which is that Trump, for whatever reason, sees himself as a law-abiding person. So, his whole business model was, oh, you built the building for me. Well, I'm not going to pay you. Sue me. But at the end of the day, as a businessman and as president, he does comply with final orders of the Supreme Court to do X or Y. And an important case was this one of Kilmer Albrego Garcia, the undocumented person who was, kidnapped and sent to the notorious prison in El Salvador. I frankly thought at that point we were in what we'd call a dual state territory, Ernst Fraenkel territory, when arguably we maybe are. But I think it's a harder case because in the end they did something totally illegal and arbitrary, and in the end they did comply with the decision to bring him back. And they're trying to make his life hell and all that, but they're still following the process. So I don't know. It's a thin reed, but it's important, and it might end up saving us. On occupation, so here's a very interesting point about international law. Under the Geneva Conventions, when you're an occupying power, like the United States in Iraq, you're not supposed to change anything. You're not supposed to. You're supposed to leave the society as it was, and whatever merits that has as a legal principle, post Saddam Iraq probably wasn't a good idea. I happen to know a lot about the Iraqi constitution-making process, and there was a lot more local involvement than you might have thought. The United States basically cared about two things. They didn't want a political Islam like Iran, and they wanted women's rights protected. But they didn't care about the presidential or parliamentary system. Afghanistan, they cared a lot about presidential system, but generally, like they're not always focused on everything. So there's always a lot of local input in those processes. You might say as a moral matter, we have a duty to do the best we can and then launch the project. But the problem is, with these interventions, is you very rarely get a Douglas MacArthur. Douglas MacArthur turned out to be a political genius in terms of this particular issue, because he issued, as those of you who studied the case know, MacArthur's governing Japan. He's going to initiate a constitution-making process because the Japanese one is super conservative that they're going to head towards. And he issues a piece of paper, basically on a napkin. He writes 4 points. That the emperor should be retained as a useless head of state, and that Article 9 should be adopted, that Japan should not have an armed force. And I think of that as an act of political genius, because what it did is it reassured to both the right and the left in Japan that there were going to be fundamental principles which were off the table. And no one could ever change Article 9, and I know it's been, you could say, eroded, but still has actual very significant bite. And of course, the emperor thing was really important to the right. Reassuring conservatives at that point in Japanese history was really important. So I think it's a stable constitutional democracy, which it's kind of boring when one party runs everything forever. But they're kind of like the Toyota of political parties. They're very efficient, just-in-time delivery. They always get just the right number of votes and stuff. And so, that's how it works.
All right, with apologies to the remaining hands, we need to move toward concluding business, of which we have a few items.
Oh, do I sit down?
For the first piece of concluding business, I'll ask you to stick around.
Okay.
I want you to hold those.
Oh, great. Oh, you're rolling a dice?
Yes. So that's a 0 and that's a 4. What is the name next to number 4 on that list?
That would be Edan Miller.
Is Edan here?
In the very
Edan,
back.
are you a current McGill student? Then you have won a copy of Professor Ginsburg's and Aziz Hook's How to Save Constitutional Democracy.
Come on down.
Published by the University of Chicago Press.